Okay. Hello, everyone. Can you hear me? Okay. Hello, everyone, and welcome to the last session of this conference, focused on the draft Corporate Sustainability Due Diligence Directive. And in our last panel, we're going to focus on business conduct in conflict-affected areas. We won't focus exclusively on the directive, but more broadly on how companies can conduct business in conflict-affected areas in a responsible way, and specifically what human rights due diligence means or requires in this context. So we have a distinguished panel today, and I would like to briefly introduce our speakers today. First of all, as a keynote speaker, we have Professor Anita Ramasastry. Professor Anita is a Henry M. Jackson Professor of Law and Director of Sustainability International Development Grad Program at the University of Washington School of Law. She just finished 6-year term as member of the UN Working Group on Business and Human Rights, as you may know, where she led the work on business, human rights, and conflict, including a report to the UN General Assembly on heightened human rights due diligence, the jointly authored toolkit on heightened human rights due diligence with UNDP, and a recently released note on the arms sectors and the UN guiding principles. Welcome, Anita. I will continue with the presentation, and then I will give you the floor. We have with us Olena Ubarova. Welcome. Olena is Associate Professor, and since 2018, she leads the International Lab on Business and Human Rights at Yaroslav Dewais National Law University in Kharkiv, Ukraine. In June of this year, Olena became a visiting researcher at Wageningen University, the law group in the Netherlands. And Olena has more than 15 years of experience in human rights as a national and international consultant in the UN Women in Ukraine, Council of Europe, UNDP, among others. Since 2017, she has been working on business and human rights in Eastern Europe and Central Asian regions. And we want to welcome Ron Popper, who is online, and he's currently Chief Executive Officer of the Global Business Initiative on Human Rights, which brings together more than 20 multinationals and a member of a number of boards, including the Institute for Human Rights and Business. Ron has been working on the business human rights agenda as a practitioner and advisor to multinational corporations for nearly 20 years. And he's also a regular lecturer teaching business and human rights courses at universities in Switzerland, Norway, Italy, and the UK. Our next speakers will be Tara Van Hoon, who is a senior lecturer at Essex Law School. Her main research areas are business and human rights, investment law and human rights, economic, social, and cultural rights, and transitional justice. She's the co-president of the Global Business and Human Rights Scholar Associations and sits on the editorial board of the Business and Human Rights Journal. She's one of the leaders of the Essex Business and Human Rights Project, through which she advises states, intergovernmental organizations, non-governmental organizations, and businesses on issues of business, investment, and human rights. Welcome, Tara. And last but not least, we have our colleague Celine Dagrasa Pires, who is a business and human rights specialist at Business for Social Responsibility, BSR, a global nonprofit organization that helps companies implementing the UN guiding principles and sustainable business strategies. Celine supports BSR consulting services with a focus on human rights of vulnerable groups, including vulnerable local communities and indigenous people's rights. And she is also a research associate of our center, and currently she's doing her PhD here with us on the topic of corporate responsibility to respect local communities and indigenous people's rights. So without further ado, I would like to give the floor to our distinguished keynote speaker, Anita. So please, whenever you want, the floor is yours.
Great, thank you so much, and my thanks to NOVA, to the host institution, and really to everybody for this opportunity. I'm actually coming to you from Luxembourg, where I'm at a conference with general counsels from development finance institutions. So sorry I could not be there. I'm jealous as I see Tara Van Ho's tweets out about what a marvelous event it is. I'm going to just speak briefly and really set the
One
stage.
second, Anita, sorry to interrupt you, but
Sure.
we are going to put the volume a bit up.
Okay, and I'll put my volume up. Is that better?
1 second.
Yeah.
Can you speak now?
Yes, sure, I'm speaking.
Yeah, it's a bit better. I don't know if people from the back can hear. Okay.
So
Yes.
let me take off. Is that better for you?
Yes, I think now it's better.
Okay, great. Well, again, let me set the stage. When a keynote speaker usually just means a speaker that's a little bit older and has been doing something for longer. But let me just really remind people that the issue of business human rights and conflict really predates the guiding principles. When I started working in this field, which is a field about corporate accountability, we were really concerned about a lot of conflicts that were occurring in the world in the 1990s and actually even before then. If we go back even further, we can think about situations such as Northern Ireland and the conflict between Catholics and Protestants. We think about apartheid South Africa, conflict of a different kind. The issue of corporate involvement and what responsibilities companies have were front and center and helped us think about what respect for human rights looks like. In the 1990s, and the move towards the guiding principles and the drafting of the norms on transnational corporations, we had the situations of armed conflict in Colombia. We had Sierra Leone and the conflict there with blood diamonds, the Democratic Republic of the Congo, and Myanmar and issues there with the military government at that time. And to some extent, as we look at the world today, I often ask myself, am I moved back in time or to that period as we look at shifts such as, again, the situation in Myanmar? But at that point, as we were moving towards the UN guiding principles, not only was there a focus on corporate accountability, but there was this focus on the issue of businesses' connection to gross human rights abuses and what needed to be done about that. And some of you may remember, and again, some of this has gotten overlooked and put on the shelf, was a few things that John Ruggie and his team did. One was that there was, of course, in the guiding principles, discussion of conflict. It's there, guiding principle 7 and others, reminding companies that in addition to the guiding principles, they had responsibilities with respect to international criminal law through a kind of complex series of legal issues, but and also international humanitarian law. So both companies, but also corporate officials might be subject to liability. So that was there. And there was a separate addenda report where Ruggie consulted with governments around what responsibilities they had under Pillar 1 to kind of police companies that may be finding themselves in conflict zones. And as the guiding principles progressed, we saw the Arab Spring, and that was again brought up new issues of what roles companies had in places like Libya, Egypt, and other places. And then finally, Ruggie, when he left his mandate, said to the Human Rights Council, I think we might need a treaty, not a big one, but a treaty that could be narrowly focused on this issue of gross human rights abuses and clarifying issues like corporate complicity. So Ruggie made those recommendations, but those reports sat on the shelf. And then in 2020, the working group said, maybe we need to relook at these issues as we think about places like Syria and Yemen, as we look at litigation against governments and companies relating to the arms sector. Maybe it's time to dust off those reports. And so we did. And the working group prepared a report to the General Assembly in 2020, where we reintroduced the world to conflict and the idea of heightened human rights due diligence. Well, unfortunately for us, in terms of what's happened in the world, that concept is now something that has become a discussion point for companies, for governments, and for civil society with the draft directive and with just generally thinking about business and human rights because of the unfortunate state of events in the world. The situation in Myanmar, the Russia's war of aggression in Ukraine, Syria and Yemen, and of course, even in Colombia, we don't have sort of full and perpetual peace, and we have transitional states many places in the world. So we're looking at this again, and this idea of heightened human rights due diligence has taken on a life of its own, but because of conflict. And I'll say to myself, you know, I got into this field because of conflict. I remember back when I was dealing with this issue, again, back in the late 1990s, there was an arms dealer, Victor Boot, who was the movie The Law of War with Nicolas Cage is about him, The Lords of War, I'm sorry. And he's about to potentially be let out of jail in a prisoner swap that Russia's going to make with the United States. And I think I've spent my whole career trying to deal with individuals like him, and here we are. But what do I want to say about heightened human rights due diligence before we hear from really key experts who are thinking even more deeply about this? The first is that we don't even need heightened human rights due diligence. What we've found in certain situations, and I think Ron Popper can speak to this, is that just basic human rights due diligence is essential for any company, and this is foundational in situations that are complex environments, fragile environments, post-conflict, or where conflict occurs. If a company doesn't know how to assess its human rights impacts, its business relationships, situations of linkage, then it's not even in a position to do heightened human rights due diligence when a conflict arises, because it doesn't really know much about its basic human rights connections to the market, to the sector, et cetera. And I think we're seeing this play out in a variety of places. So the idea is we need human rights due diligence before we even need heightened human rights due diligence in order for companies to be able to actually move and have processes in place. The second thing that we're learning is that we still don't really know what essential heightened human rights due diligence looks like. The working group theorized and said, well, we need to look at conflict dynamics. We need to look at indicators of atrocity. So are there sort of warning signs? You know, are weapons being amassed? Or is there a situation of escalating violence, of gun violence? Are there ethnic tensions? What are these different issues? And so we need to do more around what heightened human rights due diligence looks like. And I want to just suggest that we're going to have a spectrum, right? That basic due diligence and heightened human rights due diligence are not like very different boxes. They are like a spectrum that will evolve over time, where certain issues for companies that are dealing with difficult or challenging environments will get into a practice of saying we have to assess certain kinds of issues because conflict may occur. So we may need to understand issues of historical conflict in a place. We may need to understand what responsible exit looks like because this particular market is fragile. So while we may not have all the answers, we know that responsible exit will become part of our due diligence DNA wherever we operate when it's challenging. So it's a sort of spectrum in the sense that there are going to be certain categories of questions or issues, I think, that companies will start to look at more regularly. And some sectors already do this. For example, the extractive sector would be one where there's going to be, I think, more of a sense of what heightened means. So those are just some general things to think about. Basic human rights due diligence is first, heightened is second, and we need to sort of focus on what that looks like, and then understand that I think this idea of heightened becomes part of a continuum for businesses depending on the sector, the market, and the timing of a business activity. So just a few last remarks, and then we'll hear from our panel, is there have been comments from CSOs and academics saying that the draft directive needs to take into account heightened human rights due diligence. Maybe, but I think there's going to be a challenge, right? Because when will a company know that heightened is appropriate? You know, is it a binary? How are regulators going to enforce that? I've really been sort of scratching my head about that. And my one suggestion is that maybe it works sometimes. So for example, re-entry into markets that were previously sanctioned or closed, maybe that's a time where a regulator can require heightened human rights due diligence. And an example of that is Myanmar, where the US State Department had the reporting requirements for due diligence for companies re-entering that were US based. So maybe something like that, where you can actually say at a specific point, we're going to require it, which isn't to say that companies shouldn't be doing it generally, but when is it a regulatory requirement? The second issue is that we still have not really fully grappled with corporate accountability and corporate crimes, that we need to really focus for companies on what that looks like. And that debate is alive and well right now, because with Russia's new laws relating to mobilization, companies that are still present in Russia may have to cooperate with the government relating to the conflict, requisition of supplies, employees being deployed. So all of these issues are ones that are still cloudy. So we need to have, I think, a greater focus, not just in due diligence, but on when does liability and complicity attach. Just a few more issues and then I'm done. The next one is, of course, local businesses. We've focused so much on this issue of transnational business activity, But it's a different calculus for local and small businesses that are from a region and must remain. And so what are their obligations, and do they actually have any defenses when they are coerced or basically forced into human rights abuses? A third issue is, of course, do we actually look at gross human rights abuses in a new way? Is there space for them in the current draft of the legally binding instrument? We haven't really focused on criminal liability as a big subject. What should happen? And we need to spend more time focusing on national jurisdictions and prosecutors for gross human rights abuses and international crimes. Amnesty International has a great project, the Corporate Crimes Principles, to bring civil society and prosecutors together, but this is often overlooked. And then finally, last two, the defense sector. The working group did release before I left a note on the arms sector. But despite the fact that we talk about weapons and weapons are being used in all of these conflicts, the defense sector seems to have been overlooked when it comes to Pillar 2 and the guiding principles. We need to change that. And finally, beyond the UN guiding principles, I'm curious to hear from our panelists, when we talk about Russia and the war of aggression, there's a difference between the active theater of conflict and Russia as a party to the conflict. And this is where there's been a lot of debate about what are the obligations of companies that are in Russia that are not in the active conflict zone. And we don't have precise answers, but maybe the guiding principles don't take us as far as we need to go when it comes to that. So thank you for the chance to share some general reflections, and I look forward to the panel discussion.
Thanks so much, Anita, for setting the scene and trying to frame a bit the discussion on human rights due diligence in conflict zones, but also on the question of criminal liability, corporate crime. So there are a number of issues that I'm sure they will come back here in the discussion of the panels. And I would like to start the discussions, and maybe I will start with Ron Popper. We have heard from Anita giving us this overview, this background, but I would like to ask Ron to reflect a bit more on what companies should and shouldn't be doing in conflict, and maybe to reflect a bit more on human rights due diligence. So Ron, please.
Thank you, Laura, and thank you to Nova for inviting me to speak. It's always difficult to follow Anita, and in fact, she's made a couple of the points that I wanted to say, so I'll try and do something slightly differently. I have worked on business projects and crisis management, crisis response in different countries, different conflict countries for many years, primarily in the Middle East, different parts of Africa and Asia. And more recently, I've been working with many multinationals on their presence in and exit from high-risk areas, and also their entry into these areas. So I'd just like to make two or three very basic points before I have a look at a couple of other points about the directive. As is made very clear in the UN working group and UNDP report on conflict areas, there are very few surprises in the outbreak of a conflict. Failure to recognize the warning signs is often the failure of risk management in a company, and the failure to carry out different types of due diligence, including very basic human rights due diligence. So Anita mentioned Myanmar, she mentioned Russia, and these are two countries that I've been involved in quite closely, and particularly talking to multinational company representatives about their presence and their exits from these countries. So if we take Russia, for example, and a very basic form of due diligence, which to my mind was missing. Companies have been scrambling to respond to Russia's invasion of Ukraine, to understand their duty of care, their footprint, etc. When due diligence should surely have been done, should surely have been carried out in 2014 at the latest, after the invasion and annexation of Crimea. And some would argue that this basic due diligence should have occurred before then, in 2008 with the invasion of Russia, of Georgia, pardon me. If we take Myanmar, the surprise that I noticed and the rush to carry out due diligence to establish corporate exposure after the military coup in February last year was disappointing to me, when atrocities, later described as genocide, were clearly known about in 2017 in Rakhine province. So there's some very basic issues of risk management and human rights due diligence that need to be done, and which are sometimes missing and highlighted by these crises when they occur. There are very few surprises. You can look at Ethiopia, you can look at DRC, you can look at Colombia, and so on. These are all predictable if you're doing consistent due diligence, and the issues on the ground are even clearer if you're doing enhanced due diligence. A second basic point, there's still some very major gaps in corporate due diligence. I'm not talking about enhanced due diligence here, basic human rights due diligence. These gaps, and I notice them from talking to companies, they occur in areas such as customer due diligence. Who are you doing business with? Real estate management. Real estate functions really do need some human rights training. Transport and logistics for me is still a huge gap in basic corporate human rights due diligence, let alone in areas of conflict. They become all the more dangerous when no attention is paid to them in conflict affected areas. And I'm happy to go into that a little bit later, perhaps during the Q&A. And thirdly, I come from a crisis management, crisis response background. And one of the first things you do when something happens, when a crisis breaks, is stakeholder mapping. It's absolute basic. And yet when companies enter conflict areas, serious stakeholder engagement as a part of the human rights due diligence process can still be very, very patchy. Yes, it's often very complex, time intensive, costly, dangerous even, but it's so basic. And failure to carry out meaningful stakeholder engagement can cause or exacerbate further conflict and endanger people and your company's investment. As is clearly stated in the UNDP and working group report, in a conflict zone, a company may not be neutral based on the business partners you choose, the locations you favor, the workers you employ. In any case, a company will not be perceived as neutral, despite what the company may think about its actions and choices. And understanding different perceptions is key and should run like a red thread through all due diligence and risk management activities. Companies think they know where they stand, but actually there are so many different perceptions of what they're doing, who they're employing, who their business relationships are with. Turning to the EU directive, I'd suggest 3 areas, and I'm sure there are others, to include or emphasize more. The first one, Anita has already mentioned, the need to carry out basic due diligence as well as heightened and conflict sensitive human rights due diligence if companies are seeking to enter or are already in conflict areas. As we know, there are many EU-based businesses operating in conflict and high-risk areas or a link to them via their value chains, and they risk becoming involved in severe human rights abuses and violations of international humanitarian law, IHL. I'd like to pick up on that IHL point a little bit. The proposed EU directive needs to emphasize that international humanitarian law, along with basic due diligence and enhanced due diligence, must be respected in situations of armed conflict. In my experience with companies, progress on implementing the UNGPs has been made, maybe it's patchy, but there's still very little understanding of IHL, which is clearly referred to in the UNGPs, and which is obviously central to how corporates need to be preparing for and operating in areas of conflict. There's plenty of good guidance and advice already out there. I'm thinking about the work that's been put together by the International Committee of the Red Cross and DCAF, the Geneva Center for Security Sector Governance. And yet IHL still seems to arouse less interest than it should among many companies, even those working in or linked to occupied territories. And third and finally, I'd like just to broach the issue of directors' duties. I really welcome the growing focus on directors' duties, including in the draft directive. And I very much hope it doesn't get watered down in the negotiations process. In my view, that would be a mistake. Decisions on how to enter, how to operate in, how to exit responsibly from conflict areas have to be high up the list of directors' areas of focus if they're exercising their duties and responsibilities. And this also means that considerable work needs to be undertaken to increase their knowledge of human rights, what respect and remedy mean in practice, the social complexities of conflict zones, the value of basic as well as enhanced human rights due diligence in such areas, and the need to invest in that due diligence. After the invasion of Ukraine and the military coup in Myanmar, I've been speaking to, as I say, to many multinational companies, heads of human rights or corporate responsibility, to see if their voices were being heard in corporate decision-making. And many of them are members of cross-functional committees within their corporations, committees that bring together representatives of legal, human rights, human resources, the business, government affairs, and so forth, who meet regularly to review human rights issues. Having said all that, and that is substantial progress on what used to be, their voice, the human rights voice, the human rights lens, I heard very clearly from the practitioners, is still not being heard by senior management when decisions are being made higher up. And that's another reason why executive management and directors need urgent training on human rights and enhanced due diligence as they make key decisions. And to remove directors' duties in this area would be a setback also for practitioners, and make the work of human rights practitioners in companies even harder than it is at present. So with that, I'll stop. I'm happy to answer questions, particularly on the gaps in basic due diligence and also directors' duties a bit later on, but we'll see how that goes. With that, back to you, Laura.
Thank you, Rob. I think you highlighted some of the important issues from the basic human rights due diligence to the sensitive conflict human rights due diligence, the importance of international humanitarian law that sometimes is forgotten companies and the director's duty. And I will come back to you regarding some of these issues. You also mentioned the question of stakeholder engagement, and this takes me to our next speaker, Celine. And I know you have been conducting field work in Latin America and Mozambique, among other regions. So I would like to ask you to reflect a bit more on how should business engage stakeholders in conflict-affected areas.
Thank you so much, Laura, and thank you, NOVA, Business and Human Rights Resource Center, for the kind invitation. And thank you and congratulations to the amazing team organizing this event, including you, Claire. Thank you. Ines, Isabel, and many more. So I have accepted the challenge to speak approximately in 7 minutes. And to answer the question on how should a business engage stakeholders in context affected by conflicts. The reason why is that at BSR, Business with Social Responsibility, we work in the field, and I conducted myself several human rights impact assessments in conflict affected area. You mentioned Mozambique, Cabo Delgado region. So Anita mentioned Colombia. I was in Colombia a month ago, and I can add more to my list. Before getting started, I would like to actually make a quick preliminary remark to connect my speech to CSDD directive. The current draft does mention engagement with stakeholders and affected right holders, but does in a way that is not aligned with the UN guiding principle. As Article 6 states that companies should, where relevant, carry out consultation with potential affected groups, where relevant, meaning optional. And to echo Anita's comments on basic due diligence obligation, companies should embed ongoing stakeholder engagement as part of any basic due diligence process. And when it comes to alternate due diligence process, in order for it to be effective, meaningful, it needs to rely heavily to be grounded in stakeholder engagement, including the most vulnerable. Ron said, this is a complex exercise. I do agree. And this is why I'm trying in a few minutes to pass some insight from field experience and building on BSR's guidance on how to conduct alternate human rights due diligence in conflict affected area that we published earlier this year, and the rapid human rights due diligence tool we developed to support company decision making. The insight I would like to share, I try to summarize in what I call the 3C rules. The 3C rules for companies to build meaningful, safe, conflict-sensitive stakeholder engagement in what we call CARAs, conflict-affected and high-risk areas. 3C, context, consultation, collaboration. Would like to start with context, the first C. So before initiating any stakeholder engagement process, companies in any areas, but especially in conflict-affected areas, need to assess the context, meaning building knowledge as far as possible about the specific local context. And for conflict-affected area, that means conflict-sensitive assessment, which encompasses the root causes of conflicts and the potential triggers for violence and state-led oppression. The key actors involved, well, are the key players. Armed group, paramilitaries, the contexts are very different. We mentioned Colombia. Mozambique is another context. So who are the key actors here? Armed group, paramilitaries, state-relevant authorities, local communities, including the most vulnerable. And when it comes to conflict-affected area, displaced people, refugees, migrants, who are the local communities involved and helping there, including aid community. And once you map the stakeholders, which I really like Ron comment, which is the key first step. Once you map key actors, you need to identify and gain better clarity on their ability and opportunity to inflict violence, but also to influence peace building. And this assessment of context should be done before initiating engagement. And you may ask yourself, as a few companies ask me, but Celine, stakeholder engagement is not supposed to actually help us inform a context assessment. Why doing this in-depth conflict assessment before initiating engagement? Well, answer is because if you don't have an accurate understanding of the local conflictive context, well, your stakeholder engagement process could actually exacerbate local conflicts. One recent example from the field, a mining company decided to send consultants, not myself, in the field to engage with local communities in an area affected by armed conflict. 2 states. The company, without much desktop research due to limited resources, choose to engage only, and as the first step, with representative of the largest communities surrounding its operation, a Muslim community. And as a result, the 2 other small Christian communities, which were located a little further away, felt aggrieved and expressed their dissatisfaction, which, as a consequence, revived the ethnic conflict between them. Why that? Lack of knowledge, local knowledge and understanding of context. So stakeholders' engagement, not grounded in in-depth understanding of the conflicts, the local context, yes, can lead to more risk for business and to increase local tensions. Context is key. First C. Second C, consultation. Stakeholder engagement in conflict-sensitive areas means engaging broadly, fairly, regularly, and securely with local stakeholders. I will go in further detail for each of them. Broadly, company needs to engage with different type of stakeholders to cross information and findings, to mitigate the lack of information, the polarization of debates and perception, the mistrust, which usually exists among the groups in the areas. Everyone, every single stakeholder, each community will have his own perception of the conflict, his subjective interpretation, his own truth. So company needs to engage broadly in order to have an accurate, as much as possible, understanding of the conflict and the human rights risk. Fairly, when it comes to mapping communities, local communities, mapping effectively means mapping not only the communities near to operation, but also the one impacted by the infrastructure the company rely on, roads, port infrastructure. And this is where you can find actually small local conflicts that add to the regional national conflict. And ask yourself about vulnerable groups likely to be highly impacted by conflict. I mentioned a few before when it comes to conflict affected area, migrant, refugee, indigenous people, ethnic minorities, LGBTQ communities, etc. Now, engaging regularly, the third, we know that the situation in conflict affected area evolves quickly, including it's getting worse very quickly. So stakeholder engagement must also be ongoing, and company need to identify and have regular touch points in order to track the situation in real time. And finally, do the engagement in a safe way, securely. Business should be aware that this engagement puts stakeholders who participate in the process at high risk of retaliation, violence, death, but also what we call SLAP, the legal harassment. So business engaging in the stakeholder engagement process have the responsibility to assess and address the risk of retaliation. An additional measure to actually answer safely the engagement process is, for instance, the use of encrypted email and phone communication. WhatsApp is not safe. So let's be honest now, in some areas circumstances, and I've gone through this myself, engagement at local level may not be possible, not be optimal. And this is where, and we discussed that yesterday, the obligation of means, the best effort approach applies for businesses. Even if it's complex, even if it's difficult, company needs to put their best efforts in the understanding of the local context and their best efforts in reaching safely the stakeholders impacted. My last C, and I ended with that, collaboration. In conflict-affected area, joining is easier than leading. Why? Because the most severe and persistent human rights issues in conflict-affected area tend to be systemic and linked to large-scale root causes, conflict, corruption, poverty, to name a few. And these issues are too vast, too complex to be addressed by one actor alone. So business should look at collaboration between peers, sector initiative, trade unions, NGOs, international organizations. And those are not just words. I know most business consider that coordination and information sharing, mostly, is neither feasible or desirable due to legal liability concerns. But cooperation would be so much cost efficient because we know how the resources to have impact are huge and how the task is continuous. So that's the 3 C rules: context, consultation, collaboration, in order to engage stakeholders in a meaningful, safely, and conflict-sensitive way. Thank you.
Thanks so much, Celine, for this clear presentation on this idea of the 3 Cs: context, consultation, collaboration. I think you raised some important issues on knowing the local context and the question of engagement in a broadly, regularly manner in order to avoid exacerbating past grievances and root causes of the conflict. I think these are key aspects that need to be emphasized. And I would like to pass now to Olena. And Olena, I know you have been working also on the question on heightening human rights due diligence, and you have contributed to a number of reports. But there is a specific angle that I would like to address, and it's the question of essential goods and services providers. So it's the same human rights due diligence for all corporate actors. What are the implications for essential goods and services providers?
Thank you for this question, and thank you for having me. And first of all, when we are talking about heightened human rights due diligence, we are talking about of course, high-risk environment. And high-risk environment is always about a need of balancing some public interests, collective human rights on one side, and individual human rights on the other side. In normal life, this dilemma is also possible, but it's not so crucial. High-risk environment, high-risk situation is always about this dilemma. And actually, the lawyers know how hard to find a balance between conflicting rights and between public interests and individual human rights. And in each cases, we need individual solutions. In each cases, we will not have developed receipts, developed algorithms, and actually the principle of proportionality, which I think is covered very well in guide on heightened human rights due diligence, which was prepared and published this year by UN Working Group and UNDP very well. And I totally agree that we need to pay attention to proportionality, but I think the most hard case when we can't find a balance because of this conflict of public interest and individual human rights, and when proportionality can't work, can't be applied. I give you some examples from Ukrainian perspective. Private mobile company operates, let's say, in Kharkiv, eastern Ukraine. Before the war, population of Kharkiv was 1.5 million. Now there are 600,000 people still, and all these people need to have access to communication, to internet, just to know the situation, to know what dangerous, and to communicate with relatives, and to have access to information about humanitarian aid and so on. And Kharkiv is shelled regularly, and equipment of this mobile company is destroyed regularly. And we have situation when employees of this company are forced to repair equipment at great risk to their life. Can we ensure balance of public interest to have access to communication and individual human rights to be safe for these employees? The same situation with municipality-owned companies which provide access to drink water, to electricity, to gas. There is an interesting situation with municipality-owned companies which continue to provide garbage collection services, and private companies which stopped to provide the same services. State-owned enterprise railway company which evacuated millions of people with great risk for their employee. If we would ask, should this company protect their employees, or should this company provide these transport services and evacuate people from dangerous territory? Now we have this situation with state-owned company Energoatom, which controls nuclear station on the southern of Ukraine, and employees of this company remain at the nuclear station, which is occupied from the end of February. And these employees are in the extremely dangerous situation. Some of them were killed, some of them were tortured. They work without any proper conditions. And again, if we ask this company and actually ourselves, what is correct, what is right decision that should be made when occupation was started? Should a company actually evacuate these employees and the nuclear station stays without these employees, and it could be very high risk situation, not just for Ukrainians actually, or should these employees be under this high risk situation and without any protection of their individual rights? And all my examples are about providers of essential goods and services, and there is my second point, that companies whose business model includes the provision of essential goods and services initially take on part of public socially significant function, and it means that such companies have its own responsibility to make all possible efforts to secure human rights, especially in situation of high-risk environment. What are all possible efforts? Again, it should be indicated in each situation individually, and it demands deep understanding of local context. And local should not be interpreted as national context, because many international companies made their decision for Ukraine in whole, but we can't apply the same approach again for southern Ukraine, which is occupied, for eastern Ukraine, which is shelled regularly, and for other parts of Ukraine, which is quite calm. And my last point, we can't propose to companies developed solutions, but we can ensure that companies will think in the right way and will find correct questions for asking themselves, for conducting human rights due diligence, where the companies ask themselves such questions and how they seek answers to these questions and what interests they try to balance are all indicators of corporate responsibility to respect human rights.
Thank you, Lena, for discussing this important issue of essential services. And I think there are, again, a lot of complexities with the idea of conflicting rights, protection of the employees, then whether to continue providing the service. And again, something that has come back, the understanding the local context. I think that's a key point that we can share with the previous presentations. And going now to Tara, another issue that has been mentioned during previous panel is the question of disengagement, responsible exit. Should companies stay? Should they leave? How can business know when to leave a conflict? And equally important, what does responsible disengagement mean? So maybe you can bring us some thoughts.
Thanks, Laura. And thanks also to Nova, to Claire, to Ines, to Isabel, and to you, Laura, for organizing what I have really enjoyed. Like, this has been a fantastic 2 days, not just because it's brought some of my favorite people all together, but also just in terms of the intellectual questions and challenges that I feel like I've been presented with for the past day and a half. So, responsible disengagement or exit. The EU directive almost addresses this. And I say almost because it does so in the preamble, but as any good lawyer knows, that only gets you so far, right? So the preamble language says that disengagement should be taken as an action of last resort and take into account the interests of those adversely impacted. And then it says nothing else. And so that leaves us with questions of when and how we should be understanding this, both in terms of when and how we understand disengagement, and also what does it mean when we talk about according to the interests of those impacted directly, right? Because as Elena just pointed out, you will often have tensions about what that requires or leads to between employees and communities, between certain communities and other communities. So we need a much clearer statement about what that means. So I'm going to tell you what it should say, and then I'm going to leave it to Ben in the back to figure out ways to draft language for the EU on this issue. So when? The answer is not as soon as a conflict breaks out, which is what a lot of times I think civil society has traditionally asked for, right? Like a conflict happens, everyone's like, go, run as fast as you can. And then we saw that in Russia and Ukraine, and it was actually sometimes the right decision and oftentimes not the right decision or not carried out particularly well. In reality, we need to understand that operating in situations of conflict and the termination of relationships are part of the life cycle of any project, and they need to be understood as a routine part of the life cycle of any project because in reality they are, right? According to the Council on Foreign Relations, as of April 2022, there were 27 ongoing armed conflicts, but those are the locations of armed conflicts, right? When you start thinking about where is the field of activity versus who's engaged, you wouldn't say that that Russia is in an armed conflict. You would say the armed conflict in Ukraine, but it does implicate all of Russia, right? The United States, well before Donald Trump, has been a conflict affected area. Doesn't consider itself that. No one else ever talks about it as such. There's a whole colonialism, racism aspect to that I'll go into if you ask me about it, but I'm going to set aside for now. But it's been in conflicts continuously for most of the last century, right? So when we talk about what are we looking for, it has to be much more holistic and much more nuanced. So when defining when to leave, the answer comes down to due diligence. I'm not sure I want to touch the debate about whether or not we need enhanced or heightened due diligence or not. I do think that when it comes to conflict, we do. But we are looking at something broader than just an armed conflict situation. The UN, so for those of you who don't know, armed conflict is a legally defined term under international law. There's a particular point that's a little amorphous, but primarily there as to when an armed conflict starts and when it concludes. But the guiding principles don't say an armed conflict, right? They say conflict affected territory or conflict affected area, which is supposed to be broader, and it encompasses pre-conflict all the way through transitional justice. And so you should be looking at what's going on. And I can't really add much to what Celine said. That was absolutely brilliant. But that's what you need to be doing to determine whether or not you need to exit. Now, if you're in a conflict affected area and you are causing or contributing, the guiding principles are really clear. Stop and remediate. That's your responsibility. There's no further discussion. There's nothing that you can do in terms of enhanced due diligence that will correct that reality if you are causing or contributing to a human rights violation, inclusive of human rights violations that are violations of humanitarian law as defined using lex specialis. Stop, remediate, don't do it again. The harder question is, what if you're directly linked to, which is where a lot of times companies start in a conflict affected area. It is unusual, not impossible, not never happened, but it is unusual for corporations to be directly involved in perpetrating violations of armed conflicts. But how do you know whether or not they're contributing or not? So the guiding principles point to the following criteria: severity of abuse, adequacy of leverage, whether terminating the relationship would have adverse impact, and according to the guiding principles, how crucial the relationship is to the business. So I want to break those down. The more severe the harm is, the more quick you need to see a change. If you are talking about a relationship that your partner is engaged in war crimes, genocide, crimes against humanity, grave breaches of the Geneva Conventions, or any other international crime, including the crime of aggression as defined by the ICC statute. You need to be sure that your leverage is going to be effective, and it needs to be effective quickly. The longer you stay in that relationship, the more likely you are to be sliding on the continuum from directly linked to contribution. And once you hit that contribution side, your responsibility is to remediate the harm. So sometimes leverage cannot be effective. Sometimes you should seek to increase leverage by working with other partners, using your collaboration, but even then, sometimes it won't be enough. So for example, if you are a business going into an Israeli settlement in the occupied Palestinian territories, you are contributing to war crimes immediately upon entry. I don't give you a day and a half. I'm not going to give you a half of a day. The moment you start operations in the settlements, you are contributing to war crimes. Why? Because you do not have any leverage. You will have absolutely no leverage to affect change. There is not a company that has yet enough leverage to affect change in that situation. You can try to lie to yourself, Unilever, and suggest that you are contributing to, sorry, I'm going to completely get myself sued for a slap lawsuit today, and I'm going to do it anyways. So you can lie to yourself like Unilever has, that you're somehow contributing to peace. You are not. You are contributing to a war crime and you need to stop. Russia, right now, your relationship with Russia, you have no leverage. You're not going to affect change. How do I know? Because no one has yet. China with the Uyghurs, which I recognize is not technically an armed conflict, but when you're hitting crimes against humanity and probably genocide, you're hitting the same thing. Saudi Arabia, when it was committing war crimes against Yemen, same thing. There are not companies that have enough leverage in those circumstances to affect the kind of change that we're talking about. So when you enter in or continue your relationships and operations in these contexts, and what you're doing is contributing to the conflict, you are moving really quickly along that continuum. Where leverage can be effective, you can stay longer. So Myanmar has always been a very tricky issue. Ron alluded to this, and we saw Telenor stay a little bit longer because for a while, Telenor actually had some leverage, and it seemed like maybe Telenor's leverage would be effective. So they could stretch out the time in which they could justify being there. The other factor, or another factor, is adverse impacts caused by staying versus leaving. Here, questions about essential goods and services matter. So if you are a food or agricultural organization and you're supplying food to a conflict-affected community, you can stay longer. Not all companies are equal, even within those categories, though. So the fact that clothing is an essential good does not mean that product can stay in a conflict-affected area. Here, I would suggest that businesses really need to look at what the ICSCR defines as an adequate standard of living and understand what that means. If you're supplying something that's necessary for an adequate standard of living, you can stay longer. If you're a luxury good or service, sorry, Mercedes, but you cannot justify staying longer unless you build cheaper cars. So this can raise really particularly difficult questions, right? So Telenor in Myanmar, if you're in the West, cell phones are fun, but they're not an essential good or service, right? Like they can be, but they're not necessarily. Myanmar, however, it was a primary access to the internet, primary access to global communication. It was also a huge aspect of banking for underprivileged communities. So when we're talking about Telenor in Myanmar, you're talking about actually truly essential goods and services. You could justify a longer stay because the adverse impacts were going to be so severe on marginalized communities. Then you get to Shell purchasing oil from Russia after the most recent expansion of its annexation and invasion of Ukrainian territory. Shell purchased this and then justified it as, but we need to keep oil for the global supply. And I agree, like we are facing an energy crisis. We are facing some serious concerns. It does have racialized and disparate impacts on developing states. It has gendered impacts. There are some legitimate concerns there. But when taken into whole context, really what Shell was doing was looking for a good profit and an access that its competitors weren't using anymore. And there, I don't think you can make the justification. I had said on Twitter that I would praise Shell today. I lied. I didn't mean to lie, but I totally lied. I'm not praising Shell today. Like they just, whatever. I'm stopping myself from getting sued by finishing that sentence with whatever. So another criteria is the importance of the relationship. The importance of a relationship is explicit within the guiding principles, but it's not a get out of jail free card. So I'm sorry, Lafarge, but like, it's really problematic that you thought that financing ISIS was acceptable because you needed access to your cement factory in Syria. You didn't have to throw a rock before you were literally watching people be beheaded. And so the strength of your relationship doesn't get past that. Also, since I'm throwing companies under the bus today, all of left, right, and center, Heidelberg, same thing with the occupied Palestinian territories. Like you don't get a get out of jail free card because it's an important factory for your operations. Instead, that has to be considered within these other factors, including the severity, the knowledge, the temporal reality, and the leverage that you can use. Where relationships are really important is actually distinguishing between foreign companies and national companies. National companies are often captive. They have to comply with what a state tells them to do. Foreign companies often don't. That doesn't mean foreign companies don't want to. Oftentimes there's a reason that they want to stay in, I don't know, China when there's a genocide going on. The guiding principles don't make the distinction between national and foreign companies, but international criminal law and transitional justice both suggest that there is a distinction. So if you look at Nuremberg, there was a defense of duress for the business leaders. But that stopped as soon as the business leaders started to take advantage of the situation, right? If they were complying with the law, they weren't convicted. If they weren't, if they were, enjoying the benefits of genocide, then they were held responsible. And there were convictions of industrial leaders during the Nuremberg tribunals for that taking advantage of. The South African Truth and Reconciliation Commission made a similar assessment, right? Compliance with the apartheid rules, you had low-level responsibility. Taking advantage of those rules, you had higher levels of responsibility. When you apply that to situations of responsible exit, there's a question of, local businesses have to stay, generally speaking. Foreign businesses don't. So right now we're watching a Danish company called Rockwool. It would be exempt under the EU law, which is a whole problem. So to tie back to the first panel, it doesn't have enough employees and it doesn't make enough money, but it's still going to be manufacturing goods and having to supply the Russian military, because last week, I've lost sense of time, so it's sometime in the last few days to a week. Putin has announced that companies are going to have to start supplying the Russian military when it asks for it for the conflict. Now you have this Danish company who is going to have to be supplying industrial wool to Russia. Does it say or does it go? It's doing it through a local subsidiary. So it could say, oh, but it's a national company. It's not. It's a foreign company. It has authority here. It has rights here to start disengagement. Laura, I know I'm out of time. I'm going to just say something about how. So this has to be planned at the start of the operations. You have to have policies on the triggers. You have to start thinking about your relationships as you would start thinking about your marriage if you were Donald Trump. And that means having some prenuptial agreements in place, right? Like, what is going to trigger the end of this relationship and how are you going to exit out of it? In addition to the questions that Celine has identified in terms of heightened due diligence, you have to think about your sales through third-party customers. So your consumers are part of your relationships. And if you're just sort of skirting by the sanctions by selling to a third company that then sells chips to the Russian military, you aren't actually doing your human rights jobs. Speaking to rights holders, both in country and in the diaspora, will give you different information. So if you're talking about Syria law number 10, if you talk to people in country, everyone's going to go, not a big problem. Why? Because the people who the law is meant to discriminate aren't in the country. They're in the diaspora now. They are refugees elsewhere. And then you have to provide reparations for all of your stuff. The life cycle of a project is not complete until the reparations are paid and done. That's it. I'm sorry. I'm so sorry.
Thanks so much, Tara, for bringing some other additional ideas to think about the responsible exit. So many factors that need to be considered, the issue of leverage, the distinguish between foreign and national companies. That is also something important to consider. And lastly, the reparations. I don't know if Anita's still here. I don't know if she has some reactions to our speakers.
Yes, so can you hear me again? Is it
Yes, yes.
Great, thanks. No, I think it was a really good and rich panel because it addressed many different facets of what we're talking about. But I think sort of to reflect on Tara's point, the challenge I'm having, Tara, with the idea of the EU draft directive and this concept of heightened human rights due diligence is how much we can prescribe in the directive versus what can be addressed anyway through the requirements of mandatory human rights due diligence and robust access to remedy. That's what I was in my own remarks leading off with, right? That maybe at certain temporal points, for example, entry into a complex market or one where sanctions are lifted, you can make those requirements and say at that point there needs to be that, which doesn't excuse companies from doing that anyway. But the failure to conduct proper due diligence or contribution to harm may still lead us to the results that you're talking about, which is responsible exit. Because as I was taking notes during your presentation, I think the balancing, and as you're talking about all of the different factors, as you were saying to Ben in the back, can he draft this, proposal, is where I'm just still thinking and perplexed. And so I'd be curious to see kind of what Ron thinks about that in terms of what we need to bake into a draft directive and what can be accomplished through regular requirements of due diligence.
Thank you, Anita. And I'm going to give the floor now to Ron. I don't know if, Ron, you want to further detail the question of maintaining directors' duties in the directive, or if you prefer to touch upon any other issues that have been discussed, so feel free.
Okay, it is a difficult issue, Anita, and I don't have a magic wand. I think the details need to be part of mandatory due diligence, and the EU directive needs to take a quite a high level approach. But there are certain touch points which it should not ignore or should not water down, and I certainly include directors' duties as one of those, because directors' duties don't feature too widely elsewhere. But yeah, I think that's a huge point that is worthy of much greater discussion. Can I just make a couple of very basic points about directors' duties, because it's a thing that sort of is preoccupying me. And I'd really like to take it back to very basics. Human rights in a company is a top-down issue and does need to be driven from the top. And it's only by having responsibility and accountability at the executive management, or indeed at the director level, that human rights will be driven through the policies, processes, culture, right through to the salespeople at the front end, and that human rights will stick in a company. Placing responsibility and accountability for human rights performance, also meaning performance in the most difficult environments at director level, sends a very strong signal to all members of a team, however remote they are from head office, that they need to carry out deep dive, conflict sensitive due diligence and not take shortcuts, and that there will be budget for such efforts. It's also a very strong signal to different stakeholder groups, from governments to investors to civil society organizations, that here is a company that is seeing human rights in human and financial terms, and that there is a line of accountability, and that they are prepared to take their obligations seriously, both in everyday business and in high-risk areas of the world. And I appreciate that really doesn't answer the challenge that you're sending out, Anita, but I really do feel that this top-down approach needs to be stressed in both mandatory human rights due diligence acts, as well as in the EU directive. I think it would be such a mistake and such a, in a way, betrayal of human rights practitioners within companies if this is watered down, that it would actually be a bit of a setback. So I just wanted to make that point loud and clear.
Thank you, Ron. And I think I'm gonna go back to Celine, maybe in relation to the stakeholder engagement, and maybe if you can provide more details on how operational level grievance mechanism could be tailored for conflict affected context.
Thank you. Can you hear me now? Yeah. Yeah, my co-panelists are taking a macro approach. I'm the one covering the micro, so I hope this is complementary. Grievance mechanism, yeah, so I did not have enough time to cover it during the 3C rules. I would like to start with a very important point in conflict affected context, and I would like to make it really clear. Businesses should maintain operational level grievance mechanism. That's crucial in a sense that during conflicts, the breakdown of rule of law, judicial system, transform actually operational grievance mechanism many times in the unique channel available for employees, for local communities. And that's very important for two things, of course, for raising human rights abuses, but also that's enable documentation of abuses for investigation, for instance, etc. That's the preliminary point I would like to cover, but actually I have specific remarks too. So behind, Principle 31 of the UNGPs, which cover the effectiveness criteria for OGM, operational grievance mechanism. In conflict affected area, I mean, there is a need for companies to understand that they need to tailor existing operational grievance mechanism, fitted, culturally fitted to the local reality. And I do agree with you, of course, local do not mean national. Local mean literally local, sometimes at community level. So tailor and fit the grievance mechanism to the severity of conflicts, considering also high risk of retaliation for the users. And that's mean also as a top priority ensuring confidentiality safeguards. And I know that we would like to have simple answers to complex questions. But to provide one example, a practical illustration from a recent field visit. If we take in consideration gender dynamics, women, when it comes to the use of grievance mechanism in conflict affected area. So women in local communities affected by conflict will not or really poorly use the complaint box placed under the tree in the middle of the village for the simple reason that they will fear being seen using it, being seen by who? Paramilitaries, armed group, public security forces patrolling in the area, but also, last but not least, and I think this is the most important point, communities' male leaders that may directly work or benefit from the armed groups' activities, paramilitaries, or may be connected with arms committed by public security service forces. So that's an important point in the sense that company needs to apply again the best effort approach to develop tailored, accessible, safely accessible operational grievance mechanism in conflict affected area. And my last point about operational grievance mechanism would be, and to echo and Anita gross human rights abuse, when grievances and complaints may refer to abuses committed by the army or armed groups, state public security forces, against people in the community, for instance, business should have processes in place to adequately and safely report crimes to national authorities and to avoid any accusation of complicity by omission. That's what I can say about in a few minutes about the operational grievance.
Thank you, Celine. And I'm not sure if Tara wants to follow up a bit on the question of post-conflict justice and reparation, maybe, for companies and your experience in transitional justice.
Yeah, I'll just say a few words on that, and then I'm going to come back to Anita's other question, if that's okay, Laura. So remediation and mitigation go hand in hand. One is taking place to try to limit the harm, and the other is to compensate or to remediate or to restore the harm that exists even when you don't have mediation or mitigation, or when mitigation's been insufficient. And so when you're doing questions around conflict, it's questions on what does that mean for the victims, right? Remediation by its nature is victim-centric. at its lowest standard, and I am saying at its lowest standard, it is to restore the victims to a position that they would have been in but for the violation. If you're restoring them to a position of ongoing and systemic violations, that's not sufficient. So you need to go to a higher standard of restoring them to a position of security and respect for their human rights. That can take place in a lot of different ways. We talk about sort of the 5 natures of reparations. So there's restitution, restoring what was taken, which is the primary and preferred mechanism or form of reparation under international law. Oftentimes that won't be possible. You cannot resurrect the dead, to my knowledge. You cannot restore arms that have been taken. And when you have destroyed an entire town, it's hard to restore that. But it is still the primary. Where that's impossible, you should be looking at rehabilitation. That's economic, financial, social, medical, and mental. And so there you're looking at what do you do to help someone transition and transition in their lives, in their operations, in their existence into something that's better than what they've been left with, but might not be a full restitution. Satisfaction or public apologies and memorializations. This is one that businesses get really hung up on because there's a recognition that if you apologize and acknowledge that you did something, that you can't do the same thing again in the future and just get away with it, right? That we recognize that you're supposed to learn from your mistake. So I've worked with companies, and I work with the civil society and the organizations who say the most important thing is an apology. We just want the business to acknowledge that what they did was wrong. And then you go to the business and say, they just want you to acknowledge. They're like, no, but we can give you money. They're not asking for money. They didn't ask you for money. They asked you to acknowledge that what you did was wrong. And it's almost always a non-starter. And so there does need to be some way of addressing that tension within the regulation. I'm not sure what that is, but I think that there does need to be something. So Ben, I hope you took a note. Satisfaction, guarantees of non-recurrence, that often will be reforms to your operating procedures and policies to make sure that you don't make the same mistake again. Sometimes I think guarantees of non-recurrence in particular circumstances means that you leave a community and you never go back. You don't try to force yourself back in. I'm not Argentinian, so I don't have the right to say on behalf of the Argentinian people, but I don't know why Ford was ever allowed back in the country. I don't know why Ford continued to operate in the country. Like you were directly involved in serious violations of human rights, in torture and violations of the right to life, and enforced disappearances. Like, get out and be respectful of the fact that victims should not have to walk by your factory. They should not have to see your cars on the street. Sometimes sometimes guarantees of non-recurrence actually means not staying in a situation. Another thing businesses don't particularly like. And then compensation, sort of the mop up, right? Compensation can be for financial or pecuniary losses, but it's also for moral and material harm, right? So moral harm meaning, what did we do to you? International law doesn't recognize punitive damages, but I think that moral harm part does include some punitive damage elements to it, right? When you're talking about moral harm, if you have been complicit in genocide, if you've been complicit in crimes against humanity or war crimes, that's significant moral harm. And you should be asked to pay significant amounts of compensation for it. And so that's really what we're looking at. Throughout all of this, you'll often see in post-conflict situations that the local communities establish their own transitional justice mechanisms. Businesses are often unwilling to participate in that, which I think is a real misstep on their part, because the failure to really engage in justice, the failure to acknowledge what you've been doing, and the failure to engage with the community in that post-transitional justice approach sacrifices further goodwill, right? Like if you were Ford in Argentina, the failure to acknowledge your mistakes leads people to continue to resent you. It can become a point and a trigger for future conflicts. It can be something that exacerbates relationships. And it means that your other your other efforts at things like social rehabilitation fail or are incomplete. And so engaging with transitional justice mechanisms is, I think, a form of reparation, and it needs to be part of that conversation. Now, there are 3 ways that I think that we can embed enhanced due diligence into the law. One is reducing the scope of responsibility, similar to what we do for sort of minerals and stuff for all conflict affected areas. It would need to be a significantly lower trigger than what we have for things like risky industries. I would love to see an EU agency or more preferably a really well-funded academic institution, possibly based in the UK, funded by the EU to help identify when is it that businesses should start applying heightened due diligence. And the reason that I would prefer an independent organization to the EU is because the first time that we have seen the politics, the law, and the finances come together and align has been with Ukraine. For the last 15 years, every time I say, but what about Myanmar? People say, politically tricky. What about occupied Palestine? Politically tricky. Sudan, politically tricky. Libya, politically tricky. Syria, politically tricky. Like, I'm so tired of hearing about how nobody can operate because it's politically tricky. Ukraine has shown us that actually these 3 things can align, that it's important for us to do that. So I'd like to see there be an independent organization separate from the EU who has the authority to say, we're now in a conflict affected area. And then it can be embedded in terms of prioritization. When do you do due diligence? How do you understand your priorities within due diligence? Conflict should be top of the line. Thanks, Laura.
Thank you, Tara, for pointing out these different forms of reparation. And I agree with the question of moral reparations and apologies. How important is that on the side of companies and other non-state actors, and the compensation for the moral damage as well. I will go to Olena just to finish up this panel, and again to the question of essential services and good providers. And what about the state duty to protect? And from Ukrainian perspective, does state impact on responsible business conduct by the essential services and good providers?
Okay, thank you. No, actually, even in more general context, the state duty to protect, is crucial, and we have a challenge that, to be honest, Ukraine can be in this context more responsible, I would say, because there is still no recommendations from the state, even for providers of essential goods and services, and also we have very complicated situation with occupied territories, because the how to say, political tricky issue. It's a political tricky issue, because Ukraine actually applies the general approach that paying taxes to occupied authorities is crime according to Ukrainian legislation, and there is no exceptions for providers of essential goods and services. I believe that in practice we will have a different approach to different businesses, but in general it's really sensitive and complicated issue for our society, and we discussed last week with Ukrainian business association, and they communicate with local businesses which actually need to operate on the temporary occupied territories, because local population still need to have access for essential services and goods, and for actually regular services and goods, and yes, and these local businesses are feeling that maybe even they are responsible for this local population and they continue to operate. Yeah, so I think that we should put on the table this question. Yeah.
Thank you, Elena. And we are a bit over the time, but I think we still can collect some questions. I don't know if anyone wants to ask anything. No, if not, we are right on time. So please join me to please congratulate our speakers today, and thanks all the speakers and the participants in a joint applause.